And back to the studio, attorney at law, Florida Bar, and fellow in public law and justice at CDD Ghana, Professor Asare, is arguing that the provisions for a presiding or Speaker of Parliament maintaining his original vote has been clarified since 1957 following some lessons learned. He says dropping this provision was not by accident, but to cure future anomalies. Professor Asare, who was contributing to a panel discussion on the Speaker's voting rights on JoyNews following the Supreme Court's judgment on the controversial legal debate, suggested that the judgment should have taken into consideration the historical antecedents of the Speaker's voting rights. Also, Executive Director of CDD Ghana, Professor Kwesi Prempeh, indicated that though he agrees with the arguments advanced by Professor Asare, he expressed worry about the over-reliance on the adversarial judicial system practiced in the country, while raising concerns about the interference of the Attorney General in a landmark case of this nature. Both spoke on the AM show hosted by Samson Ladi Anyanene.
Report of the Committee of Experts. And none of these things are actually referenced in the opinion. I was quite surprised by that. Now, Samson, the office of the Deputy Speaker is not a new thing. If you go back to the 1957 Constitution, there was a Speaker who was a member of the National Assembly and a Deputy Speaker. In 1969, we had a Speaker, but that Speaker, because of experience, was made a non-member of Parliament. And then he was also assisted by one Deputy Speaker. Then in 1979, because of the experiences of 1969, the non-MP Speaker was retained, but this time it was decided that he would be assisted by two Deputy Speakers, one not from both parties. This is what the 1992 Constitution also retained. So when you do that evolution, you can learn a whole lot of things. So for instance, let's go back to the 1957 Constitution and then read something from there. In Article 40, 2A, it provides that the Speaker shall have neither an original nor a casting vote. The Speaker, okay? Remember, that Speaker was a member of Parliament. That Speaker was a member of the National Assembly. But Article 42A provided that the Speaker shall have neither an original nor a casting vote. But more important, Article 42B of the 1957 Constitution provided that any person, including the Deputy Speaker, shall, when presiding in the Assembly, have an original vote, but no casting vote. So this was the 1957 Constitution. It specifically had a voice on whether or not the Deputy Speaker has an original or a casting vote, and it also told us that the MP, who is a member of National Assembly, did not have an original or a casting vote. Then we learned some lessons. So we went to 1969. In the 1969 Constitution, at Article 82(1), it also provides that the Speaker shall have neither an original nor a casting vote. And this is important because the Speaker at this time was not a member of Parliament. The Speaker at this time was not a member of Parliament. So he doesn't have an original vote is not directed to the speaker who is not a member of parliament. It is directed to somebody who is a member of parliament who performs the function of the speaker. So in 1969, you will notice that the Article 42B on the deputy speaker having an original vote when presiding is completely dropped from the 1969 Constitution. This drop was not some accident. It was constitutional framers looking at our history, looking at the 1957 Constitution, and learning from that and deciding that this notion that a deputy speaker or a person presiding will retain an original vote was obnoxious, and so let's drop it. Then we come to 1979. 1979, Article 86.2 basically also has the speaker shall have neither an original nor a casting vote, and there's no reference to a deputy speaker. And finally, we have the 1992 Constitution, which basically copies from the 1979 Constitution and explicitly rejects the language of the 1957 Constitution. I believe this type of analysis is what I want to see when the court is making a determination as to whether or not a standing order that has been in existence for 30 years and which was copied from 1979 and 1969 is constitutional or not.
Yeah, so
when you look at that history, as you must, we learn a couple of things. One, the notion that a member of the assembly could lose his original vote is not an alien concept in our parliamentary history, as we saw in 1957. Two, the Constitution tends to be specific when it allows a non-speaker presiding member to retain his original vote. This is the model that was used in 1957. Third, the provision that allows a non-speaker to retain his original vote was not just conveniently omitted or forgotten.
Right. Okay. So Prof. Yes. Yes.
In 1969.
Prof. So
when you put all that together, what you learn is that our Constitution, when it comes to the question of presiding members of Parliament, have seen an evolution from when the Speaker was a member of Parliament who did not have a vote, original or casting, to when the Deputy Speaker or presiding member had a vote, to the current situation where both anyone acting as a speaker, the speaker substantively, and a speaker pro tempore has no casting vote.
Right. So, Prof, the question is, you're talking about you are talking about an important evolution. So, if in 1957 the Constitution was specific in saying that any other person, including the Deputy Speaker, shall, when presiding in the assembly, have an original vote. That's what is said. How do you explain the absence of this specificity in the subsequent constitutions?
That's what I explained, that it has been consciously dropped.
Consciously dropped?
Yes. I mean, it was there in 1957 when people were writing the 1969, 1979, and 1992 Constitution. They had the 1957 Constitution. It was part of the ingredients that went into the formulating.
The court takes decisions using principles of law. And you clearly would have read the judge or the court say, make reference to the expressio juris exclusio ulterius rule, where the expression simply means is that
the expression of one thing implies the exclusion of another?
Well, I mean, apply that rule in this case when the particular clause dealing with the deputy speaker has been dropped. Well, what does that rule tell you? That rule tells you it has been dropped and a court should not reinsert it in the Constitution. Because if the framers wanted to insert it in the Constitution, they had a template. It was right there in 1957. They could simply have copied Article 42B from the 1957 Constitution.
So hold on briefly. We'll return to this substantive issue, but let me bring in Professor H. Kwesi Prempeh. Thank you very much, Prof, for also joining us. Prof, I started Professor Kwaku Asare on his concern about the absence of Parliament in the suit, and actually proceeds to pronounce that that renders the judgment nugatory. I can't find, as it were, statutory or judicial decision to support that, but he makes a case. Now, you also express concern about that, and you say that as the matter involved or implicated directly setting rules of the House and ruling of the Speaker, I was expecting to see more than just the private plaintiff and the Attorney General as the parties represented in this case. Specifically, I had expected to see separate representations of the Speaker in this case. Anyway, we shall save that discussion for another day. The plaintiff takes a position that aligns with the position of the minority in Parliament. The Attorney General goes to do his job by virtue of Article 88 of the Constitution and canvasses the contrary position. What else do you expect Parliament to be doing in the case?
Thank you, Samson, and thank you for setting up this discussion with my good pal, Kwaku Asare. We are not usually in court on opposite sides. So it's good to be in this court of public opinion, representing different sides of the matter. But I think Kwaku does in fact raise a germane point on the procedural issue about the parties in the matter. Thompson, you have to put this in the context of our adversarial system of justice. We operate an adversarial system of justice, which means that in a matter before a court, the court relies on the advocacy of the two sides to tease out the issues before the court so that the court would get a full measure of the issues, the arguments, and the like, right? And we try to make sure that the persons before the court are the right persons who will most zealously argue the point. So the private plaintiff here is just like you and I, just like you, me, Kwaku, any other citizen of Ghana. It's an Article 2 plaintiff. They are a nominal plaintiff. It doesn't mean that they necessarily have a special interest in the matter or an interest in the matter that is larger than the interest of you, me, and Kwaku. So they are a nominal plaintiff. The real party in interest, who is not before the court, is really someone with a more substantial interest in the outcome of the case, somebody who is probably the custodian of the rules of the House, which is the Speaker. That person's proceedings, right, the custodian of those rules, it is that person or that party whose rules, whose actions are actually implicitly before the House, before the court. I think that for the court to have the most zealous advocacy before it, for the purposes of our adversarial judicial system, you have to find that plaintiff or that party who is not before the court, but who is the real party in interest in this case.